Good morning, everybody. This is Alex Folk. I am a vice president in Cordium's compliance consulting group. In this role, I consult investment advisors on regulatory compliance matters, and I am joined today by Mark Zwillinger. Mark is the founder and managing member of Zwilgen Law Firm. He counsels on issues related to the laws governing internet practices, including issues related to the Electronic Communications Privacy Act, the Foreign Intelligence Surveillance Act, data breach notification, and data privacy. So thanks everyone for joining us today. One quick note before we begin, we'd like to make this session interactive if we can, so please let us know if you have any questions throughout the presentation and we'll try to comment on those. So I'm assuming everyone that is listening today knows a little bit about alternative data, but today we'll go into some detail about the subject. In this webinar, we'll discuss what alternative data is, the legal framework for data collection, and how managers can identify, assess, and mitigate the potential legal and compliance risks that arise when using alternative data. We'll also go through some practical case studies so that you can see the application of the risk mitigation strategies that we'll be discussing. So what is alternative data? Alternative data is typically comprised of large, unstructured data sets. Often, these data sets are so large or unstructured that the information is difficult for an investment advisor to manually process. Therefore, most fund managers hire third-party data vendors to process and structure the data for the investment management firm's use. However, there are some that use internal data scientists to gather and analyze alternative data. A lot of times this data is fed into other technologies such as machine learning solutions. For example, machine learning can be used with its natural language processing to interpret text found in news articles, tweets, and draw some conclusions about public sentiment. As you can see on this slide, it shows different categories of alternative data. The first category on the upper left there is data that's generated by individuals. Those are things like social media posts, forum posts, or product reviews. I recently learned that there are 6,000 tweets that are sent every single second. So you can imagine the large volume of data that would need to be processed to discern any useful information from those 6,000 tweets sent every second. Next is data generated by sensors, things like satellite images, geolocation data, or drone images. And I know Mark is going to share some information about privacy laws that affect the use of this type of information later in the presentation. Finally, we have data generated by business processes, such as commercial transactions and credit card data. One thing that's interesting about this category is that often alternative data is gathered and sold as the byproduct of a different intended use of the product. This type of alternative data is referred to as exhaust data. And an example of that is users who use an account aggregator for managing their financial affairs, for example, mint.com, and that aggregator can offer financial behavior insights to investment advisors based on that usage. You hope that they anonymize that data before selling it, but you'd have to check your privacy policies. Exhaust data is rapidly gaining in popularity. According to Forrester's 2017 Data and Analytics Survey, there was a large jump in the number of companies that are turning the data into their data exhaust into new revenue stream. 48% of respondents said that they were commercializing their data in 2017, which is up from 32% in 2016. As you can see when you look at this slide, these are not new types of data. In fact, investment advisors have been using alternative data for a long time. In particular, those advisors with a quantitative strategy have been incorporating alternative data into their research processes since the mid to late 2000s. However, a few factors have changed in recent years to make the use of alternative data more prevalent among all types of asset managers. First, the availability of data has increased as our use of technology has increased. In fact, IBM estimated that 90% of the data available today has been created over the last 2 years. Second, our ability to process large volumes of data has rapidly increased in recent years. Regulation is also spurring the push into alternative data. Recent rules, including MiFID II's research-related requirements, as well as the SEC's focus on restrictions around the use of material non-public information, make it a lot more difficult for investors to generate alpha from traditional sources of information, such as company filings or research reports. As a result, investment advisors are looking towards alternative data to identify trends, ideas, or signals that could help produce the outperformance that will allow it to stand out from its peers. As a result, we've seen a lot of service providers moving into this space. The vendors are focused on new ways to harvest the data, and then they analyze and structure that data to produce some tradable insights. And Mark, do you want to talk about legal categories of alternative data?
Absolutely. So this is Mark Zwillinger, and as Alex said, I represent lots of entities, but including 20, 25 funds on questions of how they can acquire and use alternative data. The first thing I like to talk about is dividing that alternative data into 3 buckets, because for each bucket of data, there's a different legal question that you have to ask yourself and analyze, both in diligencing the vendor and deciding what kind of use you can make of the data you obtain. So the first type of data that you need to think about is data that is obtained from public spaces. That is satellite insights data, drone data, surveillance footage. Is the data really from the public? When you put up a drone and flew it over a parking lot to count the number of cars in the parking lot, were you in public space the entire time, or did you take that drone and fly it over private airspace? Did you acquire pictures of private individuals in private positions, or were you validly in a public space? Similarly, you might take drop cams and line them up in front of a window and point them at a shipping facility and determine the number of trucks going in and out. Is that space public space where you put the cameras? The second type of data is the data that is obtained allegedly through the consent of users. That is credit card financial transaction data, mail inbox data, VPN data. And for this type of data, the question is, was the consent validly obtained? I'll give you an example. Geolocation data, or I'll give you a more specific example of mail inbox data. If you are going to try to get data that's from a mail provider with regard to the types of things that somebody is purchasing or acquiring, and they're getting receipts back to their mailbox, that is sharing of what would otherwise be very confidential information protected by the Electronic Communications Privacy Act. So that mail provider would have needed to get the consent of individuals in order to disclose that data, even if they're doing so in an anonymous and de-identified format. So was that consent validly obtained? You might have to trace from the alternative data provider back to the actual mail provider and look at the consent that was put up on the website to make sure the legal risks there are satisfied. The final type of data is the data that you might obtain from internet sources without the express consent of the source. What's that mean? That's web scraping data. That's the data you might acquire by going repeatedly to a website, and notwithstanding the fact that they might have some terms of service at the bottom that say this data is available for everyone's use, but you may not use robots or spiders to take the data, you're doing so. Okay, you did not get the express consent of the site to do it. You don't have the express consent of the users, but you obtain the data in an automated fashion. You believe the data is public data, and you then take that data and take some insights from that data and use it for trading. For that type of data, the question is, was the data obtained through authorized access? That is, even though the website might have discouraged you from doing it, does the law permit you to go in and scrape that data and use it anyway? In many cases, the answer is yes, and a lot of alternative data platforms and data science is built on scraping data because it really is public data. So those are the 3 buckets: public space data, data based on consent, and web scraping data. One final point on the data based on consent. When it says on the slide, this is CA. CA is referring to Cambridge Analytica. Cambridge Analytica has gotten in quite a bit of hot water, and people who were getting data from them a bit of hot water for the way they obtained data from Facebook users. They claim that they got consent from Facebook users. That is, Facebook users filled out a survey, what's your personality type, and by agreeing to do that survey, they authorized Cambridge Analytica to pick up data not only about them, but about other users, their friends, their network. Cambridge Analytica thinks they got consent, but was that consent properly obtained? Does the law recognize the way in which they got it? Were they upfront about it? Was the purpose disclosed? Was it a valid consent? And in this day and age, it's not enough to just say that there was a term somewhere in the privacy policy that let somebody know that this use could happen. We have to make sure that that consent was made in a valid way. Otherwise, what you could face, at a minimum, is the headline risk of having been a customer of Cambridge Analytica, relying on their contract that says we're in compliance with laws, relying on their assertion that they got consent, but yet that consent is not one that we are willing to recognize as valid. Moving on to the next slide, let's talk a little bit about the legal side, about why we're asking these questions. Because we're not just asking these questions to avoid headline risk, although that is a reason. We're also asking these questions to avoid actual legal liability. So what are the statutes that go into play here? First, it's the Computer Fraud and Abuse Act, the CFAA. That statute makes it a crime, right? Not just a basis of a civil lawsuit, but a crime to obtain information from computing systems without authorized access or in excess of authorized access. So when I say we have to ask the question, were we authorized to obtain the data, we're asking that to make sure we don't have Computer Fraud and Abuse Act liability. We also have to worry about ECPA, the Electronic Communications Privacy Act, and wiretap issues. When I use the example of the mail provider, if a mail provider were disclosing information without the consent of the user about the private mail that was on their network, they would have liability under the Electronic Communications Privacy Act. And in certain circumstances, the people who take that data could have liability under the Electronic Communications Privacy Act. So we have to worry about that. In my Cambridge Analytica example, we have to worry about a privacy violation, typically Section 5 of the FTC Act, which prohibits deceptive and unfair practices. It is deceptive and potentially unfair to represent one thing to consumers and do another. So if we're getting data from an alternative data vendor who is deceiving users into getting their consent or claiming they have consent to do one thing when they really advertise it as another, that is a potential FTC violation. And if it is a medical provider or a financial institution, they have separate obligations under HIPAA or Gramm-Leach-Bliley. To a lesser extent, but still on the radar, we're worried about breach of contract claims, where you have signed up and agreed to a terms of service with a site, and then breach that terms of service by doing one of the scraping or other activities that would help you acquire alternative data. We're not really worried about a lot of liability from that. The recourse mainly is to kick you off the site. But we are worried about a breach of a duty that might give rise to insider trading liability, which Alex will talk about in a few minutes. And finally, we're worried about trespass claims. If you abuse the access to a website such that you interfere with their ability to operate the website, we could be looking at trespass to chattels. And if you copy large portions of a website and republish that information, like the allegation is maybe in the coupon cases that have been brought, then you might have some intellectual property liability. So these are the major legal risks. There's always the headline risk, but these are the major legal risks that you would face in use of alternative data and the things that we're trying to avoid through our advice and policy prescriptions. Alex, back over to you.
Okay, so I'll take it from a compliance standpoint. I think that the compliance risks come up primarily because you're getting a lot of data at one time and you might not know exactly what's in that data and how it was obtained. The first is that the data collected contains material non-public information, and of course you run the risk of insider trading by trading while in possession of that information, and we'll get into that a little more on the next slide. The second is that the data contains personally identifiable information, and as a reminder to everyone, PII is any information about an individual that can be used to distinguish or trace an individual's identity. So that includes things like names, addresses, and telephone numbers. The issue with PII of individuals is that it's heavily protected under US privacy and data security laws, as Mark's already gone through with us, as well as individual state laws. Furthermore, the European General Data Protection Regulation, or GDPR, will very soon, actually tomorrow, come into effect, and it's quite comprehensive. So it may affect your ability to use or possess the PII of European citizens. Finally, there's regulatory risk. What I mean by that is the term alt data has been somewhat of a buzzword for the last several years. So regulators may begin taking a more specific interest in exactly what advisors are doing in this space. And I think the Cambridge Analytica case is a great example where regulators are starting to notice, it's starting to get a lot of press, some of the risks that are involved in using alternative data. And there are, frankly, some unknowns about how the laws will be interpreted in the context of new technology. Moving on, as promised, we can talk a little bit about insider trading before we move on to the case studies. So not surprisingly, there aren't any specific insider trading laws that govern alternative data. We're stuck with the same old rules, and we're applying the analysis to a new type of information that's gathered in a new type of way. The fact that there are a limited number of cases where we've actually seen insider trading laws applied to the use of alternative data, that leads to that regulatory risk that I was discussing just on the previous slide. There's an interesting question, I think, in insider trading around how insider trading cases will actually be prosecuted in the alt data space. As you all probably are familiar with, under the misappropriation theory, insider trading liability occurs when information is received from a person or entity to whom the recipient owns a fiduciary duty or other relationship or trust and confidence. Misappropriation has historically been found as well when information was collected in a manner that is considered deceptive. So the bottom line here is that if the alternative data you're getting is collected in a manner that is considered deceptive, and that information is material and non-public, there could be an insider trading problem. Just a note, misappropriation has been found in hacking cases, but so far as I can tell, it hasn't been found in web scraping cases. But I think it probably could be conceivably, depending on the details and facts around the web scraping. For example, if you're misrepresenting your identity to do the web scraping, or if you are getting around some sort of technological protocols, potentially the SEC could find misappropriation in those cases. And I know Mark is going to talk about that a little bit in our first case study as well. There was, in fact, an insider trading case actually just decided last year in the Third Circuit Court of Appeals, and it dealt with alternative data. I'll give you a quick rundown of the facts of that case, just so you're familiar with a real life example. The SEC alleged that the defendant misappropriated material non-public information from his employer, which was Capital One, to trade in securities. So what he did was he created a computer code which enabled him to scour a credit card sales database for specific companies' credit card revenue data. Then he imported that data into an Excel spreadsheet. Then he used that information to trade in those companies near their earnings announcement dates and made large profits. The defendant actually admitted that he violated Capital One's employee code of conduct, thereby confirming the misappropriation issue that I was just talking about. However, in court, he actually argued that the information he received was not material. And a jury decided that a reasonable investor would, in fact, have considered the information significant in making an investment decision, and they convicted him. And I should say the conservative approach, of course, is to make sure that you don't trade on material non-public information at all, so you're not asking the misappropriation question. So we'll talk a little bit more about reviewing data for material non-public information later. So now let's turn to the case studies. Mark, do you want to lead us through this first one?
I'd be happy to.
Now?
Yeah. So let's talk about a typical web scraping request that we might get from a fund that is looking at in the retail space. I'll lay out the hypothetical and then give you some tips on how we would analyze that from a legal perspective. Of course, I'm not providing legal advice to anybody on the phone. You're not my client, so I don't rely on it, but I will give you the guidelines of how I would look at the issue if asked. So an analyst wants to scrape a furniture retail site in order to download price data, and they want to find out how they're pricing the product, and they also want to place orders for the purpose of gleaning information from the order sequencing. For a lot of retail sites, you can figure out from the order numbers, the algorithm that they're using to increment the numbers, and if you place orders on Tuesday and then orders on Wednesday, you can have a guess about how many orders were placed in the interim. So the site has a terms of service that says anyone is allowed to visit the website, but no bots are allowed. No spiders, no bots, no scraping. This is a typical provision in terms of service that you might find on the internet. But a user doesn't have to agree to the terms of service to look at the prices. That is, they're down at the bottom in what we would call a browse wrap, not a click wrap where you click through it, but in the bottom in a browse wrap. But in order to place an order for this site, you do have to create an account and say that you agree to the terms. So the question comes up, can they do this scrape? Can they do this scrape internally? Can they use a third party? Does that help? Can they do the pricing but not the order placing? You know, what would be the way to look at it? So if we go to the next slide, we have some of the legal questions that we would look at in order to answer the question. The first question, as I said from before that we're going to answer, or we're going to look at to ask and then answer, is whether or not the person is accessing the site without authorization or an excessive authorization. I don't know if the presentation is paused, but if we can go to the next slide, all the questions will be up there for you. So again, the first question is, are you accessing the site without authorization? So let's think about it. Anyone in the public is allowed to access the site. The terms say so, and you don't have to agree to the terms in order to get the pricing data. It's available to everyone. Clearly, the public is authorized, so getting the pricing data doesn't seem like it would be a problem. But what about that wrap agreement that says you're not a bot? Well, again, you haven't agreed to it, and for the purposes of the Computer Fraud and Abuse Act and for the purposes of the MNPI analysis, this is public information, and everyone in the public is authorized to get it. The site is trying to restrict the method by which you download it, but that is not an access restriction. That does not say certain people are entitled to see it and not others, the way you would need to if they had a password to access the site and you guessed at the password. So for the first part, it's a fairly easy question. You haven't agreed to any terms. The site is public. Everyone's authorized to view it. You can probably scrape the pricing data. What about the placing the orders? Well, first again, with the authorization question, you are a member of the public, you're authorized to go to the site, you're authorized to create an account and order. You might not be complying with the contract on the website, but everyone in the public is allowed to place the order. So the initial order does not seem to be a problem. Now, if you keep doing this over and over and over again, we start to get into question 3, in which case you might be interfering with the site's functionality. You might be preventing valid customers from placing orders, especially if you're trying to return the product. You might be ordering so frequently other people can't order the product. So you might be doing some harm to the site. They might want to kick you off. But right now, even with the browse wrap agreement that you've agreed to, you are not looking at unauthorized access to the site or unauthorized scraping of data. Now, a site that sees you doing this, it might want to block you. They don't want their information scraped. They don't want this order to happen, so they might start to put in some technical measures to try to block you from the site. They might put up an IP block. They might put up a CAPTCHA to make sure you're not a bot. And for those of you, everybody's probably familiar with CAPTCHA. It's the bane of our internet existence, but you have to click the little boxes on the screen that say, you know, these are the ones that have a street sign in them, or here are the numbers that I can read from this blurry page, and enter that to prove you're not a bot. Now, if you keep doing things on the site, if you circumvent those blocks, if you try to go to the site even though they've put an IP block in place, now you're starting to circumvent a technical measure that the site has put in place to keep you out. And it becomes harder to argue that you are authorized, an authorized user of the site. The main way a site will try to block you, ultimately, is to send you a cease and desist letter, which says you may no longer access the website anymore. That is a clear revocation of authorization. Taking it back to question 1, you're no longer authorized to visit the site. The site has told you that, and then you're left with a couple choices of 1, stopping, 2, calling the site and negotiating some sort of license to get the data, or 3, suing them for claiming that they're not allowed to block you from the site. And that's exactly what a company called HiQ did to LinkedIn earlier this year. And I'll tell you a quick story about this, and then we'll move on. So HiQ is a site that was trying to get insights from people's behavior, and they realized that the more people update their LinkedIn profile, the more likely it is they are to leave the company and be looking for a job. So they were trying to sell to the companies on LinkedIn who have employees there insights, scores about how likely a current employee is to leave. And they were doing this based on public LinkedIn profiles. And they were scraping LinkedIn, and LinkedIn didn't want them to do this for obvious reasons. 1, people won't use LinkedIn if it's their boss is going to find out that they're thinking about leaving their employment. And 2, LinkedIn has its own data set that it might want to sell. So they engaged in a little cat and mouse game with HiQ. They tried to block them. HiQ tried to get around it. They sent HiQ a cease and desist letter, and HiQ received the letter and sued LinkedIn and won a preliminary injunction against LinkedIn to be able to continue to scrape the data. The court in the Ninth Circuit, which was in California in the lower court, and now the case is on appeal in the Ninth Circuit, said that this is public data. They weren't looking at any private LinkedIn profiles. They were only looking at the profiles of people who made their profiles public. This data is available to everybody to look at, and if that's true, then LinkedIn can't restrict the method by which HiQ looks at the data. They can't block them. They can't kick them off their site. It's a very pro-scraping decision. Now, I wouldn't say everybody outside the Ninth Circuit should rely on this, but in California, we are in a very pro-scraping environment, and a site has to do even more in order to prevent you from scraping the data. That doesn't necessarily answer all of the MNPI analysis that Alex will do, but it's a good sign that a site can't make its data available to all the members of the public and just try to put in a no botting restriction and prevent people from scraping it. The answer, again, would be different if their site was only designed to be certain members of the public, like a site just for doctors, and you had to misrepresent that you were a doctor to go to the site. Final point I want to make here is if you are going to make competitive use of the information, you are much more likely to be sued or blocked than if you're making research use of the information. Almost all of the cases about scraping, and we've read about 20 of them in preparation for the advice that we give to funds, come up in the context of a competitor scraping someone's site to make competitive use. None have come up yet in the context of an analyst or an investment advisor or a fund looking at web scrape data for the purpose of making an investment. Could it happen? Sure, but that's not where the case law is today. Alex, you want to take it from a compliance perspective?
Yeah, moving on to compliance. First, on this slide, I don't talk that much about insider trading, but I do think that misappropriation question that you raised, it hasn't been brought up in the courts yet. So it's a little bit of an unknown exactly, what would be considered, misappropriating and what wouldn't. And certainly, if you're misrepresenting yourself or, that would be far more towards the scale of it being misappropriating data. But then, to your point, if you're accessing information that's already available to the public and then just aggregating it, that would be probably less likely to be considered misappropriation. But just generally speaking, of compliance, what you can actually do in a web scraping case, if you're performing web scraping yourself in-house, I think that it's important to have a policy in place, and I think that's pretty standard for compliance. In that policy, you should be requiring that employees, if you're doing your own in-house web scraping, or vendors, if you're hiring someone else to do it, follow technological protocols and refrain from circumventing impediments to automated data collections, like the ones that Mark was listing. Also, depending on the frequency of the data collection, the policy could require permission of the CCO prior to performing web scraping. Either each time you go forth and have a web scraping, or just overall have the CCO's approval of that plan of action. The policy should also discuss the risk of insider trading and protocols around insider trading. For example, promptly informing your CCO when you're in receipt of any non-public information, and of course, maintenance of a restricted list. One thing to consider is actually working web scraping or other alternative data collection into the firm's broader MNPI policy. Finally, the CCO should always review the data for MNPI and PII periodically and then annually as part of the compliance program review. I think the compliance review is a great opportunity to do some forensic testing in this area and go back and take a sampling of the different data that you've received through web scraping to see if it does contain any information that looks like it might be material non-public information. Mark, do you want to go on to the second case study?
Sure. Let's look at geolocation data. But before I do that, this is a good time to remind you that if you have questions about anything we've discussed today, please feel free to type it into the questions box in the box that should be on the right side of your screen. You may need to hit the triangle to open it up. When one of us is talking, the other one can be looking at the questions and answering when we switch off. So please do that if you have questions. So here's a case study on geolocation data. A hypothetical provider called Locate Me says it'll provide aggregate data on mall traffic on a daily basis based on apps that are running on users' phones. They can provide aggregate insight data about how many devices are in a mall, or they can give you raw data tied to each device identifier they have for all of their users over time, including all of their GPS tracking. Can you buy that data? Can you use the aggregate data? What about the raw data? This is a question that actually comes up with some regularity. If we flip to the next slide, we can go through some of the questions that it raises on the legal side and then on the compliance side. So the first question is, and remember back on slide one when I said with this bucket of data, the question is, did they get the valid consent of the users? And it's not just any consent, it's valid consent. So there was some controversy, again, in the headline risk category a couple months ago when there was an allegation that AccuWeather was asking people whether they would consent to have their GPS information tracked. And if people said no, they were tracking it anyway. And the dispute was what AccuWeather asked. It said, you want your location data on, yes, no. If you said yes, they got your GPS data. If you said no, they used your Wi-Fi information to triangulate where you are and guess at your location. So was that a valid consent? Did users who said no consent to have their information tracked by AccuWeather? Some people would say yes, some people would say no. The people who would say yes would say that was in the privacy policy, that AccuWeather would do that. The people who would say no, say that thing popped up on screen, made users think that if you said no, they wouldn't be tracked. So what do we do when a vendor wants to offer us this type of data? The first thing we want to do is try to see if we can get the actual consent. What apps are they working with? Can you show us the example of the consent the user would have received? It is fairly obvious that if somebody who's doing a weather app probably consented, in most cases, to tracking or giving the weather app the GPS data so that they could tell them what the weather was in their area. And that's the way a lot of these app panels get the GPS data and then pass it along. But did they say that they would be able to disclose it in a de-identified or anonymous way, or were they silent on that? Did they say they'd be disclosing Wi-Fi data even if they said no to the GPS data? So we want to look at that and get some representations about that. And the second is the device identifier versus the aggregate. It's much easier and safer to get 40,000 devices were in a mall than to get these are the 47 devices that went to the mall, and here are the other places that those devices went over the course of a day. One, the data itself can be identifiable. Over the course of a day, people leave their home and go to work, and they do that, every day. So if you have their data over time, you can pretty much identify the likely home location and work location of people when you have that kind of line level data, and that's not the data you want or need for your analysis, so you don't want to have that. You especially don't want to have that if it's users in the EU, because all of the EU data at that kind of line level, even if it's based on device identifier and not their name, is going to implicate GDPR, the General Data Protection Regulation, and you're going to be tracking EU users over time, and you're going to become a data controller for all the data that you have with some obligations to those users. So processed data, aggregate data, much safer than line level data. Location data is sensitive, so we're going to want to make sure that there was adequate consent and not take data from providers, mainly for the headline risk, but potentially for being involved in a privacy litigation for having PII of users without their knowledge and consent. Alex?
Thanks, Mark. So I think from a compliance perspective, it follows on with the legal issues. The biggest risk here is personally identifiable information. Vendors should really be anonymizing the data to reduce your risk. And if a vendor's not willing to do that, I think it's probably worth a lot more diligence into that vendor. In this case, it might not be possible to anonymize the data, and then it's worth evaluating how important that data is to your investment process, given the risk that's involved with having PII. This brings up another important topic in compliance in this area, which is vendor due diligence. It's important you understand how the vendor is actually getting the information that they're selling to you. So make sure you inquire about the source of that data and include related reps in your agreement with that vendor. I would even consider digging deeper by asking the vendor to actually show you the documentation, the consents in this case, that supports that the data they're selling you has been acquired legitimately and may also be sold. And as for any service provider, make sure that you're performing due diligence on your vendor at least on an annual basis. In that diligence effort, vendors should also be agreeing to follow their own privacy policies, which would be important, especially if you're getting that information from a regulated entity that is required to have a privacy policy. Finally, just like in the last scenario, I think CCOs should be reviewing data periodically to make sure it's what they expect. It doesn't contain any material non-public information or any personally identifiable information. And just to say again, can't say it enough, as a compliance consultant, I feel I would be remiss not to mention that you should document that diligence that you perform. And then finally, our last case study here. Mark, do you want to take it, sir?
Sure. So we're going to talk about acquiring credit card data, sort of the easiest form of alternative data we hear about that people want to buy right away. A lot of vendors out there who are selling it. There are opportunities to buy it from card brands, from merchants, from processors. And so we are still in the category for this of consent for the user. The question is, when did the user agree that this data could be shared? When did the user agree that the data could be sold, and for what purpose? So first question is, how was the data obtained? Where did the data come from? And where did the consent of the user come into play? So if you're getting the data from a typical provider like 1010 Data, you're going to be getting credit card data at an aggregate level. And it's not going to disclose any information about who the buyers were. It's not going to allow you to track them over time. And that information is going to be like the data at the mall, safer and easier to use. If you're going to be getting line-level transactional data, if you're going to be getting the type of data that Yodlee and others might provide to you, you're going to be able to make some of the same conclusions about the user that you could be making from the geolocation data, where they bank, who their employer is, lots of different transactions in there that will allow you to re-identify data. And what you don't want to have in your possession is re-identifiable data. So you want to stay at the aggregate level to begin with. Second, we're also going to be looking for the consents, but here we're going to be looking for a different type of consent, because as I mentioned at the beginning, there are specific sector-specific laws that apply to privacy of user data. One was HIPAA, one was Gramm-Leach-Bliley. Financial institutions are not going to be able to disclose this data to you unless they have sent a valid GLB notice to their users, and unless they have gotten the consent of their users for data sharing with non-affiliates, which is what you would be. So certain vendors are going to have the ability to get you better data than others, and financial institutions are going to be less likely to provide you with data. Card brands and aggregators are going to be more likely to provide you with data. So you want to choose your source of the credit card data clearly. You want to make sure that you are getting adequate consent, and that they should be able, again, to keeping in line with all of the things that Alex has said, to document the way in which that they got the consent to give you the data. But I would have to say that the majority of our clients who start with alt data start with insights that they get from credit card data that is properly anonymized and de-identified, as opposed to credit card data that can be used to re-identify users.
Okay. Thanks, Mark. And I think from a compliance perspective, it's the same things we've said before. I think this underscores just the importance of diligence on a vendor. And how much diligence you do could vary depending on the riskiness of the vendor. So, you know, if you feel like one vendor is maybe a riskier or carries more risk than another, sending additional written questionnaires throughout the year, checking with counsel on the legality of the activity and MNPI risk, checking more references, having additional reps in their contract that cover all the things that Mark's been talking about, and doing more testing on the data received before trading on it. And finally, you know, we'll wrap it up with just a couple of slides that talk generally about key questions and things to think about when using alt data. First, just key questions. Before you're using alt data, maybe you should be asking, is there already a firm-wide approach to alt data? Has senior management and the board said anything about using it? How would the use of alt data align with existing priorities, as well as its risk appetite? You know, as we've probably made clear here, using alternative data is not without risk. So is this something your firm is interested in getting involved with? How was the alternative data obtained? We've been talking about this quite a bit in this presentation. The same laws that apply to traditional information sources, they apply to alt data as well. If this data is improperly obtained or in a manner that's considered deceptive, then you should definitely steer clear. Who is the supplier? A lot of firms are now supplying alternative data, and I think it's important to inquire about the source of that data, review the data periodically, and monitor the activities of the vendor on an ongoing basis. Be sure that you do all the normal vendor onboarding checks initially and on an annual basis. And if the vendor is a startup or in another high-risk category, find out if you should do some additional due diligence on that vendor. Next, what does it say in the contract? Does the contract with the vendor specify that the data came from a legitimate source, that the vendor didn't violate any internal policies or technological protocols, and that it's legal for the vendor to actually sell the data? We recommend that the vendor supply a written explanation of how that data is actually obtained and why they're authorized to sell it. Next, what will the alternative data be used for? Firms should make sure that their intended use of all alt data complies with existing regulatory requirements. Using data to find out market saturation or market demand may actually have different implications than using data to actually trade directly, especially when we're thinking about insider trading. And finally, what does legal and compliance think? Similar to our first recommendation, asking if there's a firm-wide approach to alt data. In today's regulatory environment, any significant outperformance is going to generate scrutiny, and compliance should be comfortable with the source and use of alternative data. And they may need to do all the things we've been talking about: review the data periodically, change their policies, ask legal about privacy issues, and new compliance processes and controls may need to be put in place to use alternative data. And it's important to discuss those things up front instead of trying to undo what's already been done. Lastly, I think it's important to document the analysis of these issues, any due diligence of vendors, and any steps taken to address the firm's use of alt data. I always say that you don't get credit for anything if you don't in an SEC exam if it's not documented. So it's very important to document all of these steps. Next, we'll go over key policy elements. First, web scraping best practices. It's important to have those in your policies to guide internal activities and help diligence third-party providers. Of course, that includes requiring that those performing the web scraping follow technological protocols and refrain from circumventing impediments to automated data collection. And depending on the frequency of the data collection, the policy could also require permission of the CCO prior to performing the web scraping. And you may want to weigh risk tolerance considerations against the value of the data for you. So sort of a risk-benefit analysis before engaging. The policy should also include a vendor due diligence process. And this is for all types of alternative data, not just your web scraping. That can include a due diligence questionnaire, standard contract clauses, the supervision of vendors, and as I said a few times, testing the data from time to time. Your policy should also require a periodic contract review and an audit for any indicators of revoked or blocked authorization, like the cease and desist letter that Mark spoke about in our initial scenario. Finally, I think it's important to think about working alternative data into your material non-public information policy. You already have all the policies and procedures that are protective of the firm in your compliance manual, hopefully. So this is a question, as I said a few times, of just applying old law to new fact patterns. So you should be able to find a way to fit alternative data into your current MNPI framework. And Mark, do you want to go over our vendors or have any other comments on policy?
Yeah, let me add a couple thoughts on vendors and remind people that we're about to get to the end of the presentation, so this would be a great time to submit your questions because we'll go into the question slide next. So rules of thumb with vendors. You can't hire a vendor to do indirectly what you may not do yourself. So you can't just get rid of the potential for harm under the Computer Fraud and Abuse Act by having a vendor do the scraping that you can't do. The more custom the service that you're going to get from the vendor, the more likely it is that the vendor will be acting as your agent, and there's a principal-agent relationship. So what do I mean by that? So you've identified a site that you think is too high risk to scrape. So you hire a vendor and tell them you want that site scraped. You're going to be no different than you were doing it yourself. But you go to a vendor, like a Yipit Data, who is already doing scrapes and has scrapes for several sites going on, and they sell it as a subscription to multiple users, then if you were to buy that subscription, A, you're reduced risk, because there's always safety in numbers, but two, or B, you didn't customize the scrape. They were going to do the scrape regardless. They're not acting as your agent. They are a vendor selling a subscription service, and the risk is more likely on them and not you. So it's much better to get a product or a subscription than it is to get a service on demand where you customize the scrape. You also have a responsibility to act reasonably in selecting and supervising your vendors. The FTC has said this for years. You can see this from the scandal about Cambridge Analytica. They could easily have been a vendor for a fund. So you can't just accept a contractual rep or warranty that they do a compliance with all laws rep where they give you a warranty that they're, complying with the Computer Fraud and Abuse Act, if you have reason to know that they're not doing that you have reason to know that the sites are scraping, have filed litigation against people who have scraped them, and yet here's your vendor offering you scrapes from those sites, you need to look behind a standard compliance with all laws rep in this space and really figure out if you're making the appropriate vendor selection. I think vendor selection here, going with everything that Alex has said about due diligence, is hyper important, at least for those companies that are very fund sensitive to headline risk, because the wrong vendor can get you in the newspaper articles and create liability for you. And I think that's it for me, Alex.
Okay, great. So we didn't receive any questions through the webinar, so I don't think there's any to answer now. So thank you so much for your time. Appreciate everyone dialing in. And of course, if you do have any questions and think of them later, our contact details on this next slide. Feel free to email either Mark or me with any additional questions you have after the webinar. Thank you.